Mr. President, may I ask unanimous consent to speak in morning business for up to 25 minutes?
Without objection.
Thank you. Mr. President, I rise this morning to join Chairman Leahy's eloquent and inspiring remarks of yesterday and express my strong disagreement with the Supreme Court's decision released last week in Citizens United versus the Federal Election Commission. In this astonishing decision, the slimmest of 5-4 majorities overturned legal principles that have been in place since Theodore Roosevelt's administration. The 5 justices who make up the court's conservative bloc opened floodgates that had for over a century kept unlimited spending by corporations from drowning out the voices of the American people. It would be hard to call this decision anything other than judicial activism. Let me start by reminding my colleagues of the long history of successful and appropriate regulation of corporate influence on elections. Federal laws restricting corporate spending on campaigns have a long pedigree. The 1907 Tillman Act restricted corporate spending on campaigns. Various loopholes have come and gone since, but the principle embodied in that law more than 100 years ago, that inanimate business corporations are not free to spend unlimited dollars to influence our campaigns for office, was an established cornerstone of our political system. Moneyed interests have long desired to wield special influence, but the integrity of our political systems always has had champions. From Teddy Roosevelt a century ago to Senators McCain and Feingold in our time, who won a bruising legislative battle with their 2002 Bipartisan Campaign Reform Act. Last week, that activist element of the Supreme Court struck down key protections of our elections' integrity, overturned the will of Congress and the American people, and allowed all corporations to spend without limit in order to elect and defeat candidates and influence policy to meet their political ends. The consequences may well be nightmarish. As our colleague Senator Schumer said, one thing is clear. The conservative bloc of the Supreme Court has predetermined the outcome of the next election. The winners will be the corporations. As my home state paper, the Providence Journal, explained, the ruling will mean that more than ever, big spending economic interests will determine who gets elected. More money will especially pour into relentless attack campaigns. Free speech for most individuals will suffer because their voices will count for even less than they do now. They will simply be drowned out by the big money. The bulk of the cash will come from corporations, which have much more money available to spend than unions. Candidates will be even more unlikely to take on big interests than they are now. What could make a big interest more happy than that? The details of this case were quite simple. Citizens United is an advocacy organization that accepts corporate funding. It sought to broadcast on-demand cable a lengthy negative documentary attacking our former colleague, now Secretary of State Clinton, who was then a candidate for president. The law prohibited the broadcast of this kind of corporate-funded electioneering on the eve of an election. Citizens United filed suit, arguing that this prohibition violated the First Amendment. The conservative justices agreed, holding that all corporations have a constitutional right to use their general treasury funds, their shareholder funds, to pay for advertisements for or against candidates in elections. Although the decision was cast as being about the rights of individuals to hear more corporate speech, its effect will be with corporations, big oil, pharmaceutical companies, debt collection agencies, health insurance companies, credit card companies and banks, tobacco companies, now all moving without restriction into the American election process. To highlight the radical nature of this decision, let me put this in the context of true principles of judicial conservatism. Justice Stevens explained in his dissent that the principle of stare decisis, it stands decided, assures that our nation's, and I quote, bedrock principles are founded in the law rather than in the proclivities of individuals. It is jarring that the unrestrained activism of the conservative bloc on the Supreme Court led them to pay so little heed to long-standing judicial precedents, brushing them aside with almost no hesitation. Justice Stevens noted that the only relevant thing that has changed since those prior precedents, and I quote, is the composition of this court. And is it truly just a coincidence that this same block of judges just last year invented a new individual constitutional right to bear arms that no previous Supreme Court had noticed for more than 200 years? Or is something else going on here, where core Republican political goals are involved? Is stare decisis now out the window, at least with the Republican activist judges? Another supposed conservative principle thrown aside by these activists was the approach to constitutional interpretation that focuses on the original intent of the founders. Read the opinions. By far, the most convincing discussion of that original intent appears in Justice Stevens' dissent, not in the majority opinion or in Justice Scalia's concurrence. Justice Stevens, in dissent, correctly explains that the Founding Fathers had a dim view of corporations. They were suspicious of them. They considered them prone to abuse and scandal, and that those corporations that did exist at the time of the founding were largely creatures of the state that did not resemble contemporary corporations. Justice Stevens rightly describes it as, and I quote, implausible that the framers believed the freedom of speech would extend equally to all corporate speakers, much less that it would preclude legislatures from taking limited measures to guard against corporate capture of elections. This lack of historical awareness is, as I will explain, not the only flaw of the majority opinion. Only the dissent points out the most basic point, and I quote, that corporations are different from human beings. That, and I quote, corporations have no consciences, no beliefs, no feelings, no thoughts, no desires. I would add, they have no souls. The dissent explains, and I quote again, corporations help structure and facilitate the activities of human beings, to be sure, and their personhood often serves as a useful legal fiction, but they are not themselves members of we the people, by whom and for whom our Constitution was established. The majority just bypasses this elemental point. One bedrock principle in our democracy is that the will of the people should be supreme, except in very limited circumstances. In the judicial context, this means that courts should hesitate before striking down statutes enacted by Congress. But it seems that that's not so when core tenets of the Republican platform are involved. And it's not just this one case. There is a pattern that is discernible when these five men get together to strike down laws of Congress they don't like and make new law more to their liking. The pattern is not just discernible, it is unmistakable. It is undeniable. It appears, indeed, to be without exception. Look at the evidence. There is virtually perfect concordance between the major departures by the activist bloc from conservative judicial tenets, such as judicial restraint, original intent, states' rights, and the result, in those cases, of achieving current Republican political goals. One could probably call this practice situational judicial restraint. A rational person could conclude, based on the evidence of the court's behavior, the observable results, that this and other decisions by the five-man conservative bloc would more properly be characterized as political prize-taking than judicial lawmaking. Mr. President, the only unchecked power in the American political system is that of a majority of a court of final appeal. When a small group can seize majority power in a court of final appeal, they answer to no one and can rule as they please. That danger is why courts are ordinarily so careful to answer to rules of judicial practice, respect for precedent, answering the narrowest question, and engaging in honorable, neutral, logical analysis to arrive at decisions. That is why this conservative majority's departure from these rules of judicial practice and the association between these departures and outcomes favorable to their political party is so unpleasant. The steady march of the activist right-wing bloc to establish its conservative political priorities as the law of the land should come to observers as no surprise. It represents the fruit of a long-standing and often very public effort to turn the law and the Constitution over to special interest groups and conservative activists. Conservative institutions such as the Federalist Society were created to groom and vet the ideological purity of foot soldiers in the conservative movement. Consider legal historian Stephen Tallis on the role of the Federalist Society in the Reagan administration. I quote, "Society membership was a valuable signal for an administration eager to hire true believers for bureaucratic hand-to-hand combat. In addition, by hiring the Society's entire founding cadre, the Reagan administration and its judicial appointees sent a very powerful message that the terms of advancement associated with political ambition were being set on their head. Clear ideological positioning, not cautiousness, was now an affirmative qualification for appointed office." The results of this meld of political ambition, ideological positioning, and judicial appointees have been terrible. Fringe conservative ideas, such as hostility to our nation's civil rights, environmental protection, and consumer protection laws, have been steadily dripped into the legal mainstream by endless repetition in a right-wing echo chamber. The mainstream of American law has been shifted steadily to the right by force of this effort, backed by seemingly endless corporate funds.